Welcome to today's update for employers on their legal obligations when addressing coronavirus. We're going to cover today a range of legislation which is relevant to employers, some frequently asked questions so that you can get a sense of how these might be applicable for your workforce, and also to discuss strategies that you may need to look to in terms of moving forwards with your workforce, taking into account the economic conditions currently. I'm Kirsty McDonald, a partner in the Employment and Health and Safety team here at Duncan Cotterill, and Alastair Espie is a Senior Associate in the Employment team. So we'll take you through this overview today, and very conscious that you may also need some tailored specific advice, and you're very welcome to contact us. In terms of today's update, we're going to look at legislation, relevant questions, and what you can do to continue to be prepared for the ever-changing climate that we're in now with the coronavirus. If we turn to those legal obligations, first and foremost there is the Health and Safety at Work Act, then there is the Employment Relations Act, of course duties of good faith and the like, the Holidays Act, which covers whether or not employees are entitled to payment or not when taking leave or self-isolating or being required to stay home. And then of course there is the employment agreement and policies, which will be incredibly relevant to your businesses and how these obligations at law fit with what you've agreed with employees. Turning to the Health and Safety at Work Act, all persons conducting a business or undertaking, a PCBU, have an obligation to ensure, so far as reasonably practicable, the health and safety of its workers. Now, of course, an infectious disease is a hazard. PCBUs are obligated to consider what hazards or risks exist in their business and what are appropriate controls to minimise or eliminate those risks. Equally, employees have obligations under the Health and Safety at Work Act to ensure that they too are mindful of their own health and safety and are taking steps in that regard, as well as following instruction from their PCBU or employer and ensuring that they follow reasonable instructions. So how does a PCBU keep up to date with the ever-changing communication and information around coronavirus? There are websites and information regularly available from the Ministry of Health, from WorkSafe, from MB, from WINS. There's a range of information available to employers. It's really important that PCBUs or employers obtain that information and communicate as needed to their employees. And this includes ensuring the basics around, personal hygiene, ensuring that the PCB understands where its workers have travelled to or where they may have returned from, ensuring that if someone is unwell they don't come to work. So there's some basics that should be communicated to workers, and obviously a PCBU is always going to be reviewing what's working and what's not. One of the positives to come out of this is that many organisations are looking to agree with their employees or consult with employees around their working from home. Most employment agreements actually contain a provision whereby an employee works in their place of work or is otherwise needed by the employer, and potentially that might be from home. So it's a good opportunity for employers or PCBUs to revisit their working from home policies and ensuring that workers have considered the risks in their home working environment, because that's also important, where they're going to be working potentially indefinitely from their homes. Under the Health and Safety at Work Act, an employee can refuse to attend work if they believe that by doing so they are going to make themselves susceptible to serious harm. Now that is quite a high threshold, but there will be situations currently and potentially going forwards where employees may refuse to come to work on health and safety grounds. So it's going to be important for employers to engage with employees or an employee around their concerns about attending work. What is giving rise to the risk in their minds? Is it something that can be worked through? Is there alternative work available in another area of the business? Or is it a case where that employee could work from home? Is the concern in fact reasonable, or is it unreasonable? If it's reasonable and you agree with that employee, actually yes, they may be staying at home for a period of time, you may decide to do that on special paid leave, for example, or it may be that actually it's not reasonable for that refusal, and once you've engaged and consulted around that, you may decide that that employee is actually going to be on unpaid leave in the event that they continue to refuse to attend work. Turning to the Employment Relations Act, one of the key provisions that underpins all aspects of the employment relationship is the duty of good faith. Now more than ever, it's important to keep this at the forefront of all your communications with employees. That is the obligation to be active and constructive and act in a manner that is preserving the employment relationship. So where the business is exploring any changes to its current operations, it should be looking to consult with employees in the first instance. For example, there is a legislative ability to direct an employee to take annual leave on 14 days' notice, but that's only after having discussed and agreed whether or not the employee will take annual leave. So it's always about consulting first and foremost. And particularly in the situations that are evolving now, that obligation of good faith is critical. If an employer is putting together a proposal that is going to impact on an employee's ongoing employment, then as per usual, there would be an expectation that an employer would consult with the relevant employees who are potentially affected and also provide information that's relevant to that proposal and support throughout that process. So certainly part of that good faith obligation is ensuring that employees have support in the upcoming weeks, potentially months. Turning now to the Holidays Act.
Given the nature of coronavirus, it's natural that employees are going to need to spend time away from the workplace. So employers are going to need to consider the entitlements of employees under the Holidays Act. Now, one of the key entitlements that will be relevant will be sick leave, which is for employees who are unfit to be at work, and also where they need to care for a spouse or a dependent who lives with them. Now, it's important to keep in mind that sick leave is only for employees who are unfit for work. It's not applicable to circumstances where employees are, for example, required to self-isolate but are not actually sick or otherwise unfit to be in the workplace. Turning then to annual holidays, that's the entitlement that employees will typically use for rest and recreation, but employees can, with agreement with their employer, use it for other periods of absence, so it will be applicable to employees who, for example, have exhausted their sick leave entitlement or where sick leave's not applicable to their particular reason for being absent. Another aspect of annual holidays which will be relevant is that while agreement should be sought between an employee and employer, sometimes that won't be possible, in which case the employer may have the option of directing the employee to use any annual holidays they have and are entitled to on 14 days' notice. Unpaid leave is not a strict statutory entitlement, but it is applicable in circumstances where an employee is required to remain away from the workplace but does not have any leave entitlement or is not otherwise entitled to be paid. Now, it's something that should be used as a last resort, but again, it's something that may be an appropriate option to cover any period of absence by agreement between an employee and an employer. Underneath leave entitlements, employment agreements and policies are going to be key. So employers are going to need to be mindful of individual employment agreements, collective agreements, fixed term agreements, and the provisions that form part of them, because these will have a significant bearing on employees' entitlements, but also an employer's options for dealing with coronavirus. Now, a number of clauses we would like to draw your attention to include a suspension clause which will be available in circumstances where an employee has not agreed to remain away from the workplace or is not otherwise unfit to be at work, but the employer is, say, concerned that the employee may present a risk to other staff if they remain in the workplace. So suspension clauses are something that might be used in those circumstances following consultation with the employee to require them to remain away on health and safety grounds. But it will be important to understand that where a suspension clause is to be relied upon, any requirement to remain away from the workplace will need to be on pay. A force majeure provision is an option which may bring the employment relationship to an end, but to stress, it's something that would be used in very rare circumstances. Now, we're talking about situations where the business is forced to close permanently as a result of a supervening event, act of terrorism, war, natural disaster, and potentially pandemic. But it's important to understand that it's not applicable just because the coronavirus situation has made business difficult or is having a significant commercial impact. We're talking about if the business simply cannot operate as a result of coronavirus, for example, due to the workplace perhaps becoming unsafe on an ongoing basis. So while it's not something that will be readily available, it is something that might be considered by employers. Restructuring provisions will come into play where employers are looking to make changes to their business, for example, due to a need to reduce roles or headcounts as a result of the difficult economic environment and the impact on their financial position. Now, restructuring is governed by extensive common law, which includes and relates to the obligations of good faith that Kirsty has talked through before. So all of those obligations will apply, but restructurings may also add an overlay in the sense of adding or specifying specific redundancy entitlements and obligations that need to be adhered to in any restructuring process. One final clause that we would like to draw your attention to is a business interruption clause. Now, this is not necessarily a common clause that you see, but it's one that, if included in an employment agreement, may provide a very important option for employers where they do need to close or reduce their operations for a period of time. Now, business interruption clauses like this one can require employees to remain away on unpaid leave, so that's very different to a typical suspension. But again, it will be very important for employers who are looking to rely on such a clause to carefully consult with employees to talk through what it is considering doing and to make sure that they understand and have a chance to comment on the employer's thinking before any decision to rely on this clause is made. And again, if a business interruption clause is to be put into effect and the employee is to remain away on unpaid leave, it will be important for the employer to at all times be responsive and communicative with the employee and to ensure that employee understands what the likelihood of the period of their absence will be, what any future plans the employer has for reopening the business, and if this is not likely to be possible, to then consider whether restructure or to understand if restructuring is a likely option moving forward.
Turning to a number of questions we've received from employers about the practicalities of these legal obligations when employees are asking questions about whether or not they're entitled to be paid or not. The first question is, can I send an employee home if I suspect they may have been exposed to coronavirus? Now, the answer to that is yes, you can, and it may be that you do need to do that on health and safety grounds. You'd first of all discuss with the employee your reasons for wanting them to go home and ideally agree a plan as to whether or not they can work from home, or if not, there would be a reasonable expectation that the employee would be paid in that situation. So the consultation piece would be around the reasons for asking them to go home, and secondly, is there a place for which they can work from home and do so? And if not, then they would remain on paid leave during that period, presumably special paid leave. Do I need to pay an employee who I require to be at home who is not actually sick? The answer to this is the employee is willing and available to work, and therefore you do need to pay that employee. That employee is not sick, and therefore it is not sick leave, but it is paid leave that they are entitled to. What happens if an employee is required to self-isolate? If an employee is required to self-isolate, for example, if they are returning from international travel from anywhere with the exclusion of the Pacific Islands, then they are not willing and available to work. Therefore, they are not entitled to payment. First and foremost, the employer should engage with the employee about whether there are alternative means to work, for example, working from home and remaining on pay, but if not, then it is unpaid leave. Can I tell employees if a member of staff has been exposed to coronavirus? Relevant here, of course, is the Privacy Act, and an employee does have a reasonable expectation of privacy in regards to their health and the information they provide to an employer. There may be instances where employees are required to self-isolate and the employer can manage the workplace without disclosing the name of that individual employee. That would be the starting point. It would only be in situations where it was necessary to appropriately control that health and safety risk, that naming the employee was critical to that we would then recommend that the employer consult and agree with the employee about the fact that their name will be provided. And if agreement can't be reached, then an employer will ultimately need to make the decision if it is critical to name that employee in order to protect the remaining workforce. But we can imagine there will be a number of scenarios where there may be someone self-isolate and there a section or an office that also self-isolates without actually having to name that employee. My employee has chosen to self-isolate. What are my obligations? If an employee has chosen to self-isolate, then they are not available and willing to work necessarily. But again, it comes back to engaging and consulting with the employee concerned. Is there an ability to work from home? If so, it may be that you agree that they self-isolate and work from home. If they cannot work from home, then legally they are not entitled to be paid, and you may explore the employee taking their annual leave and then going on to unpaid leave. My employee still intends to take personal travel overseas. What can I do? As you'll be aware, currently workplaces are all ceasing international travel that is not absolutely critical. In terms of someone travelling in their personal capacity, an employer can and should be engaging and consulting with that employee in advance of them taking leave to that international destination, with a view to discussing how they are going to self-isolate on their return, assuming it's not a trip to the Pacific Islands. And of course, that employer is not obligated to pay that employee when they do self-isolate on their return. It is personal travel, and therefore it'll be important for an employer to have engaged in that conversation early on. So if agreement can't be reached around the employee taking further annual leave or going on unpaid leave, for example, then the employer will have 14 days to direct the employee to use any remaining annual leave, and then will be on unpaid leave. What happens if schools close? If schools close, employees are more than likely going to need to be at home managing children who will no longer be at school. If that is the case, employees aren't willing and available to work. They can't come to work, but of course they may be able to work from home. There are going to be some challenges around this if there are childcare responsibilities at the same time. So the starting point is that an employee is not entitled to payment if the schools close and those employees are at home with their children. Having said that, again, employers should engage and consult with staff if this does become a reality for workers, and try and discuss and agree either flexible working, reduced hours, or situations where they may be able to work for a period of time, etc. And otherwise, again, coming back to it may be use of annual leave and potentially unpaid leave.
Can I require my employee to provide a medical certificate? When an employee is on sick leave, you can require them to provide proof of illness or injury. So you can require them to provide a medical certificate. If they've been away for longer than 3 days, that will be at the employee's cost. However, if the employee is in the workplace and the employer is requesting a medical certificate because, say, they're concerned that the employee might in fact have coronavirus or may have been exposed to someone who does, well, you can certainly ask the question, and we would suggest considering doing so as part of meeting your health and safety obligations. But in circumstances where the employee refuses, well, you couldn't necessarily then require them to undergo a medical assessment, in which case your options will be to consider whether or not it actually is safe for the employee to be there, or if there is a concern that's unresolved, whether this may be a situation where you need to look at suspending the employee to remain away on health and safety grounds. What questions can I ask my employee to assess whether they are at risk? Well, as part of your obligations as an employer, you will need to take all reasonably and practicable steps to ensure a safe and healthy workplace, and that will include inquiring into your employees' travel arrangements and whether or not they are suffering from coronavirus or have been exposed to anyone who has. So reasonable questions to ask include what the employee's intentions are if they have an upcoming period of annual leave, and asking them whether they have any symptoms related to coronavirus. An employee may not answer these questions, but if they fail to do so, and there is a suspicion that they may pose a risk to others on health and safety grounds, well, that's when an employer might then need to look again at suspension as an option. How my employee is refusing to attend work due to concerns about infection. Where an employee refuses to attend to the workplace, they may be relying upon the provisions in the Health and Safety at Work Act, which allow an employee to refuse to undertake work where they consider on reasonable grounds that there is a serious risk to their safety and well-being. So the key question when an employee refuses to attend the workplace will be, is their objection reasonable? And to assess this as an employer, you're going to need to inquire into why the employee is refusing to attend to the workplace, which will mean speaking to them, asking them questions and understanding what their concern is. And if at the end of the day that concern is reasonable, then the employee can remain away from the workplace. If not, well then they're not willing and able to work and are not entitled to be paid for any period of absence. But given the climate, we would strongly recommend still consulting with the employee and trying to reach agreement on alternatives, such as them taking annual leave. What if I need to close my workplace? If you reach the unfortunate situation where, due to coronavirus, you need to close the workplace, for example, due to health and safety concerns, or due to an inability to maintain operations in light of the level of disruption going on, well then as an employer, the key thing here will be to comply with your obligations in terms of good faith and in terms of being responsive and communicative with employees. So that will mean consulting with them about the possibility of a workplace closure, consulting with unions where applicable about any possible options as well, and then ultimately making a decision having taken on board any feedback you've been able to gather. If the closure has to proceed, well then options will be to try and reach agreement with employees for them to take leave. But if you can't reach agreement around this, then it may be that you need to pay employees as they will still be ready, willing and able to work unless they're otherwise unfit to attend the workplace. What cost-saving options can an employer consider? A lot of employers will be considering whether or not they need to restructure their business. In all cases, that should be a last resort. In terms of cost-saving options, employers will naturally be keen to avoid having to restructure their business, given that this will mean disestablishing roles and potentially making employees redundant. So options we'd suggest considering which will alleviate financial pressure will include trying to reach agreement with employees to them going on unpaid leave for a period of time, trying to reach agreement to hours of work or days of work being reduced, and ultimately offering employees the option of purchasing additional leave in return for a deduction in salary.
We have summarised the frequently asked questions, the legal obligations and resulting financial implications in a table for you. Now, of course, the government has recently announced a package for employers and measures to assist with sick leave, self-isolation, etc., which may be of significant support to a number of employers. But it's set out in these tables as the legal obligations when considering those questions and how they might apply to your business. Turning to pandemic planning, most employers are already well into considering how they are going to manage during this ever-changing current environment dealing with coronavirus. So what can an employer be doing now? It's about ensuring you are across the risk of coronavirus in your business and taking appropriate controls. And of course, ensuring you're compliant with the Health and Safety at Work Act by reviewing those risks and the control mechanisms that you have in place currently. It's also about ensuring that you are familiar with the employment documentation you have with employees. For example, employment agreements, whether that's individual employment agreements, collective employment agreements, fixed-term agreements. Ensure that as an employer, you understand what your legal obligations are and what you've agreed to with employees in situations such as restructuring or business interruption, as Alastair spoke of earlier. It's also important as an employer to understand what employees' leave balances look like, so that when employees raise either the question of self-isolation or schools close and they are looking to potentially be at home without the ability to be working from home, what annual leave may they be able to take during that time, and if they don't have annual leave available, when that will run out and when they will then be on unpaid leave. So it's important to be able to communicate that correctly to employees as and when the situations arise. As we've discussed earlier, it's incredibly important to communicate regularly with employees. This is going to be heightened with a number of employees, particularly in white-collar workplaces, working from home. It's also important when considering strategically what the business plans are moving forwards to ensure that you're open and honest with employees and communicating what those proposals look like, what information employees may need to have to feedback on those proposals, or if you are looking, as Alastair suggested earlier, at agreeing some cost-saving mechanisms, then being as open and transparent as you can around what they look like and the options available to employees. Then it's about future planning. No one really understands how long coronavirus is going to continue to impact the health and well-being of people and also the financial implications. So it's about planning ahead and ensuring the business has a strategy. Part of that strategy is, of course, ensuring health and safety of workers and their well-being, but it's also about what are the options available to explore financially with employees, ideally consulting with them and communicating along the way. That concludes today's update for employers on the legal obligations when dealing with coronavirus. Very conscious that each and every workplace will have slightly different situations arising for them, and the employment agreements, policies, etc. are likely to dictate how some of these obligations are applied in particular circumstances. And then if you are looking for tailored specific advice for your business, then please do reach out to one of the employment partners here at Duncan Cotterill, for which you have those details. Thank you.